Well, good afternoon, and thanks for turning out on such an awful day. We're both joined online and obviously in person for today. There's something like 200 people signed up for it online, so there's a degree of interest, obviously. So we're going to be talking about the framework, obviously. Queen's Law School is sponsoring this in cooperation with Mitchell and with the Irish Centre for European Law, and we're grateful to all of those. The issues that we're going to address are several of the most important legal issues arising out of the new agreement, and that will include the following. So just to give you a sort of agenda items. First of all, we'll start with the impact on trade and goods. And then state aid. We'll turn after that to examine, as it were, some of the more constitutional aspects of it, in particular the Stormont Brake and some of the implications of that. Then we'll turn to the role of the Joint Committee and the other EU committees that are responsible for implementing some of this. We'll turn then to the role of the Court of Justice. And briefly on the human rights and equality dimensions of the framework. So the objective of the seminar is legal and informational, and it's really quite important that that is, for us, the point of today. It's not the politics of it, and it's not advocating any particular position on it. We're talking about the legal implications of it. So speakers, I'll introduce all of them just to save time. Billy, who's online and is looking after his sick child, thank you, Billy, for joining us, is going to be talking about trade and goods. Stephen Abram from Goodbody is going to be speaking on state aid. Gordon, who's present with us as well on the Stormont Brake and some of the constitutional questions. I'll address very briefly human rights and equality issues. Katie Hayward, who's joining us from Brussels. She's been spending the week in Brussels talking to various people. We'll be talking about the EU committees, in particular the Joint Committee. And Aoife, who's here together with us, will talk about the role of the CJEU. Speakers will have a maximum of 5 minutes. 10 minutes, just to panic you, sorry. 10 minutes, and I'll be chairing and moderate the questions for those in person, and there'll be a roving mic and those coming in on Zoom. And for those of you who are coming in on Zoom, if you can use the chat function to write your question, and I'll pick it up from there. So we'll begin with Billy and Stephen on the issues on trade and goods and state aid. And then to reduce the time where Billy is going to be exposed to the potential conflicts between talking to us and looking after his child, I'm then going to take a break in the sense of we'll turn to questions specifically on Billy and Stephen's stuff. And if we can restrict our questions at that time to state aid and trade and goods, that'll enable us to then focus specifically on those issues, and then Billy can withdraw gracefully. Then Gordon on the Stormont Brake, me on equality and human rights, and Katie on committees, and Aoife on the Court of Justice. And then that'll be followed by 40 minutes of Q&A more generally, but specifically on those issues that they'll be dealing with. So we'll aim to finish by 6:30. Earlier, if there are no issues arising, I suspect that may be either optimistic or pessimistic, depending on your view. I should say there is press present, and therefore, and very welcome to, and therefore both in person and online. And I've specified that there's no recording and no cameras. It's not Chatham House, so you may therefore be quoted unless you make it clear that you are not to be quoted, please. Tweet as you wish using our new hashtag. I have no idea what that means, but apparently it means something. And you can tweet as you wish. We will be recording it, and we plan to post it on QUB's YouTube channel. Who knew? Here's details for connecting to visitor Wi-Fi. Basically, you just go on to your normal and connect to the cloud, and it'll take you to the various ways of connecting from that. So that's the modalities. We'll turn immediately then to Billy, and Declan should be helping us, but he has now disappeared. Billy, if you can come in, that would be great. We can hear you.
Yeah, brilliant. All right. Sorry I couldn't be here, couldn't be there. You can probably see the puffy hair of my child right next to me. But anyway, Chris, you haven't given us a lot of time, and you've warned that you're going to be very strict in enforcing the time limits, and I've got the extra pressure of Ruben here. So the audience will probably be relieved to hear that I'm not about to give you a comprehensive analysis of what's being proposed from a trade perspective in the Windsor Framework package. So instead, I'll focus on some of the headline changes, and really I'll only be giving you an overview of what's been proposed and some of the issues that might potentially arise. So the first big change. So the first big change is the creation of this new green red lane system, and I use that in quotation marks because it's new, but actually it essentially repackages the at-risk system, which is the central pillar of the protocol as it currently stands. And so the idea is that goods from GB or the rest of the world don't have to pay EU tariffs when they're not at risk of being moved onto the EU. The modified regime does two things, broadly speaking. It expands the categories of goods and persons who can benefit from the green lane, and it provides that goods at risks are not only absolved from paying EU tariffs, they also benefit from simplified customs procedures. The second big change relates to the import of certain retail agri-foods into Northern Ireland, and the big change is that for goods such as products of animal origin, composites, contact materials, so the regulatory burden there is significantly reduced, as will be the number of SPS inspections carried out at the border. And also they can access Northern Ireland with a general rather than an individual certificate. And of course, some of the goods, whose imports were previously prohibited can now access Northern Ireland under certain conditions. The third big change relates to trade in medicines. So these reforms are already underway. They're already in motion prior to the Windsor Framework. But the framework now ensures, if it's implemented, it ensures that medicines from GB can lawfully be placed in Northern Ireland with just a UK authorization. So just a few brief comments on these reforms. First, the good bits. All of these reforms are, in my opinion at least, a genuine attempt to address practical concerns that have been voiced by Northern Ireland stakeholders, particularly industry, concerning the operation of the protocol. So for example, for the past 3 years, business has consistently been asking GB businesses to be allowed to register to the Trusted Trader Scheme, and that's included in the current package of reform proposals. Secondly, maybe not so good, leaving aside the fact that all of these easements are highly conditional, and the monitoring and the implementation mechanisms so complex that you do slightly worry about the long-term viability of these solutions. Leaving those things aside, none of these reforms are perfect, right? It's great to have a green lane, but right next to the green lane, you have to have a red lane. And so the Irish seaboard is still there. We have to be clear about that. It might be a little less visible, a little bit less expensive, but it's still there. The disapplication of EU law on agri-food goods moved into Northern Ireland from GB also creates the risks that Northern Ireland businesses will be placed at a competitive disadvantage. And actually, I can recommend a blog that was written by my colleagues, Dr. Grave and Dr. Whitman, excellent blog on this. There are other issues I would add to that, is that it places challenges on industries here in Northern Ireland that rely on an all-island integrated supply chain. And the reform of medicines arguably has the effect of actually creating a border within the island of Ireland. So the framework solves some problems, but I would say that it also creates some new ones. So I've covered the good, the bad, usually it's the ugly, but I'll go with something a bit nicer. The beautiful, let's say. Over the past few weeks, you will have heard a lot about how the framework marks a significant departure from the protocol. But in fact, all of these reforms are or could be achieved within the legal parameters provided by the protocol. So the framework doesn't really rewrite the protocol. It uses the flexibility which is present in the protocol to address operational difficulties. So I just wanted to finish with this because I spend most of my working life working on the protocol, and it gets a really bad rap. But whatever it lacks for in certain areas, it does make up in terms of resilience and flexibility. So I'll leave it there. Thank you.
Thank you. That then led to the Windsor Framework. So what was the legal position that actually changed under the Windsor Framework? Well, in terms of actually black letter law, nothing changed. Anything that was covered under Article 10 under the Windsor Framework, under the protocol, is still to apply under the Windsor Framework. What we have received is some guidance both from the UK and EU in terms of its application. So what this joint declaration from the EU and the UK actually says is that there needs to be a real foreseeable effects and should be material, a direct and genuine link. The mere placement of goods on Northern Ireland market is not sufficient. What that really is dealing with was the concept of what's known as reach back, where that a company that only has a peripheral interest in Northern Ireland or minimal interests could suddenly find itself being caught by Article 10. And hopefully what that goes some way to address is the concern that there would be a chilling effect between GB and Northern Ireland in terms of potential trade. If there was concern that any measure that was going from GB to Northern Ireland could potentially be caught by Article 10. So that's to be welcomed. What the text is in black is actually what is separate to the joint declaration. That comes from the UK's command paper, and it goes much further. What it's really trying to emphasize is the fact that it'll only be in extremely limited circumstances that Article 10 will ever come into play. So if, and this viewpoint is that the minimal chances that Article 10 will ever be in play. What also the EU and UK have done is committed to producing guidance on actually the application of Article 10. And for anyone who's actually followed the rollout of the Subsidy Control Act, is that there's been some excellent government guidance as to when it comes into play and the principles that are applied. So if that kind of principles can actually be replicated, we could end up in a situation where finally businesses in Northern Ireland could actually find themselves in receipt of some very helpful guidance that's clear as to when Article 10 comes into play. I'll leave it there. Thank you.
And thank you very much. We can now take questions, if we may, specifically on the trade in goods and state aid issues. As I said, I'll be moderating those. If I can now come out of this and find the chat function. No, I certainly don't want to do that, do I? That would have been much too exciting.
I guess the bright red stop share.
Ah, thank you. Great. Thank you. If we can take some questions, someone has their hand up in the online. I'd prefer actually if you'd write your question into the chat function. That'll be, I think, a lot more efficient. Okay, questions from the floor.
It's just a question of the architecture. So this new Windsor Framework in common with its predecessors has a series of interlocking components. And you've been referring, I think, to what's a draft declaration, isn't that right?
Correct.
And indeed, there's a series of draft declarations. And it rather appeared on a very quick scan to me that this is the most detailed of the draft declarations. Is that correct?
Out of a series of fairly short declarations, perhaps it's the most, but there's not a huge amount of detail even within it.
It's short on detail, even though it is the most detailed, isn't that right?
Yes, correct.
And then the fact that it is the longest is purely in terms of bulk. My question really is, does that reflect any kind of hierarchical approach to the controversies and the misunderstandings pertaining to the protocol itself?
No.
I wouldn't necessarily go to that extent on the basis that, I mean, there's been a variety of issues that have been raised in relation to the protocol. And I wouldn't necessarily say that state aid has been the primary area of concern, so therefore hence putting some sort of hierarchy. However, I do think that for certain businesses wanting to know whether they'd be in the same place as other businesses, particularly in relation to their GB counterparts and how that would help them.
Great.
And let's face it, state aid is a confusing issue, and therefore perhaps it just needed that level of extra detail to be able to finally provide some level of clarity to it. So,
And I think one would rank this as an improvement on its predecessor, isn't that right?
oh, very much so. It's finally we've now got to a point where we actually do know where we sit with it. So.
Thanks. Yes. Please.
Can I ask in terms of public procurements? I think it's unpick the regime. It's all basically obviously we're going to be in the European market for goods, but UK market for everything else. And there are great declarations in the paper saying this will protect the integrity. Protect the integrity of the UK market, protect the integrity of the EU market. But are we going to have two systems, public procurement law, and will there be a cross-border market or effect in terms of procurement of goods? Or do we know really what is intended?
I'm happy to pick that up with the, I don't know, Billy would like to come in on it.
Billy, would you like to come in on the procurement point?
Perhaps I could start until Billy answers. So I'm sure as you will be aware, there is new legislation plans in terms of post-Brexit procurement regime, which will fully apply to Northern Ireland, so that we know that's forthcoming. It is due to be coming into place this year. It looks as if the legislation will be introduced in the autumn. It won't be implemented until spring of next year. So from that basis, Northern Ireland is not in a different procurement position than any other part of the UK. However, in terms of that aspect about, well, how do the EU rules still apply, et cetera, like that, there's still a standard basis of equal treatment of anyone who bids for a contract. So whether that comes from ROI or any other nation, providing that they can show the relevant, meet the eligible criteria, et cetera, like that, there's no reason why they couldn't continue to participate in Northern Irish procurement processes.
Billy, do you want to come in on that? No. Steve, can I ask a question just before you go on? So there's this interesting question that's arising not just in the state aid context, but also more generally about the relationship between statements from the UK government as opposed to statements from the EU, as opposed to joint statements. And you said in the state aid context that the UK command paper went further than what seemed to be the joint statement. Can you just unpack that a little more? I mean, are they inconsistent, or are they just more ambitious, or what? How do they diverge, and does it matter?
It's an interesting point, Chris. And the EU questions and answer section, particularly around state aid, et cetera, like that, is more nuanced in terms of the language it uses and is more reduced in terms of context. Clearly, the UK government has gone out of its way to realise that actually state aid issues were concerned in Northern Irish businesses and has therefore taken its time to do a more detailed response on those points. Does it materially matter? Difficult to say at this stage. What I think it will be very interesting is whenever both the UK and the EU produce their guidance documents that they've promised us as to how they see Article 10 working in practice. If they diverge, that will really be the key elements. If they're broadly aligned, then I think we know that we're finally in a good place at that point.
Billy, can you come in at this point? Yes. Can you hear us?
Yes, I can hear, but I didn't hear the question.
Yeah, the first question really was with regard to the public procurement issue. Perhaps would you mind?
Yes, as I understand it, Stephen said, Northern Ireland will be within the UK general procurement regime. However, obviously, we're going to be within the European system vis-a-vis the free movement of goods. Does that mean, in effect, we're also going to be subject to the European goods? And does that perhaps allow for a clash of EU law and UK law?
Yeah, hello?
Yeah, Billy, we hear you.
Yeah, I mean, the answer to that question, I'll be honest, is I'm not quite sure. So it is something I'd have to look at. But as far as I understand, that we haven't had many issues there so far. So I'd be surprised if it's a major issue, but it's something I would have to look at.
Could I, if you don't mind, I can throw you a question as well, Billy. It's really on 2 points that you raised. One was on the question about the implications for what we're now calling borders. So there's basically, I think we're saying that the border in the IRC is reduced in terms of its effect, but still remains to some degree. And you were worried that in some contexts, there might be effectively a resurrection of greater controls having to be exercised on the island of Ireland in terms of a border on the island of Ireland. Can you just talk us through how that works? Because it seems to be that instead of getting rid of one border on the Irish Sea, we now are going to two, or is that an exaggeration?
Right. So
like buses coming along, you never get one and then two come along at the same time.
Yeah. So the point I was raising was specifically with respect to trade in medicines, in particular Article 4, paragraph 1 of the proposal, the regulation proposal that was published by the European Commission, which indicates that medicines which have received a central authorization, so from the EMA, could not be lawfully placed within the Northern Ireland market. And in addition to that, you have the simple fact that if medicines which have been approved by the UK, the relevant UK authority, can be lawfully be placed in Northern Ireland, but they can't bear the EU safety features. It stands to reason they can't make their way over to the Republic. So there is de facto a regulatory border. How that will be enforced is, I guess it's down to the implementation and coordination processes that they'll be implementing over the next few years if this goes through. But yes, there is. I suppose this is the trade-off, right? The trade-off, we're talking about Brexit, it's always the trade-off between regulatory autonomy and market access. And the protocol was not simple, but it did have the benefit of a little bit of simplicity insofar as Northern Ireland was fully within the EU customs and internal market regime. So we didn't have to worry about that border within the island of Ireland. The moment you start blurring the lines, then that border progressively starts to reappear. And I think this is something that probably hasn't been talked about much in the context of the framework proposals, but probably deserves a bit more attention.
And there's a question from the on those online. It's really a question to both of you, and it's a question from Vincent Power in Dublin, who's a colleague of yours.
He is, yes.
I think. So the question is really how you think the Windsor arrangement is going to work in terms of if the UK were to conclude a free trade agreement with a third country. In other words, what's the relationship here in terms of how easy or more difficult, or indeed what just the impact is of the Windsor Framework on negotiations on free trade agreements? And I'm assuming that some free trade agreements will incorporate questions on state aid as well. But I'm assuming also that it's primarily going to be trade in goods that are going to be impacted. Billy, do you want to come in first?
Yep, you can still hear me. I'm just checking.
Yep.
So, well, we already have a couple of trade agreements that have been concluded, right? We have the UK trade agreement with New Zealand, with Australia, where, you know, we're making good progress. So DIT is making good progress with the CPTP, Comprehensive and Progressive Trans-Pacific Partnership. It's easier that way. And yes, there is a risk in terms of Northern Ireland's ability to participate and to fully benefit from these trade agreements. And that's down largely to the at-risk regime, right, where there are significant tariff differentials between the EU and UK. Then goods are deemed at risk and therefore can't access Northern Ireland under the preferential terms of the trade agreement. And of course, if the UK, the problem really arises when the UK starts negotiating trade agreements with countries that do not have trade agreements with you, because that's where the tariff differential starts becoming, you know, very important. I've not seen, well, I suppose that there is one mention, sort of, as far as standards are concerned, there seems to have been an attempt. So that's, again, yes, it's a proposal for regulation. This is an attempt to facilitate their access in terms of, with respect to standards. Although they're still subject to a lot of, you know, if you're rest of the world good coming via GB, you're still subject to a lot of, to some EU regulatory standards. That said, I don't think standards were ever going to be a real problem, because most FTAs, even these modern, you know, deep free trade agreements, don't go that far. So I think the main issue is tariffs.
And how can that be sorted? I mean, what do you envisage that? How do you envisage this actually playing out in practice?
How can it be sorted? Well, you could align with the EU and ensure that you have similar levels of taxation on imported goods. Barring that, it's really difficult to see how you can avoid that tariff differential that's problematic. So alignment would be the solution, but obviously we know that's not really something that's being envisaged by the UK government right now.
Thank you, Stephen.
Very limited to add from that. So Billy's given an excellent summation of the key points. All I suppose I would say is that generally speaking, whenever free trade agreements or any sort of trade agreements are entered into, there generally starts off with a set of a comparison of the respective rules of each country in terms of how accessible it will be to access trade from one country to another. And in terms of broad strokes, where the rules relate to things and where the UK is and things, even in post-UK or post-Brexit world, I'm probably likely going forward, let's face it, they aren't going to be massively different. Therefore, I don't see how Northern Ireland's position in terms of the single market, et cetera, like that, would in any way inhibit or cause concerns from just the high level principles that can often lead to a trade agreement. Perhaps, I suppose, there is obviously potential for unintended consequences or looking at things down the line, but I don't see that would necessarily inhibit such trade agreements being entered into anyway.
Thank you. Other questions? Okay, thank you. Billy, thank you very much indeed. We wish your son all the best, and we wish you even more best in terms of looking after him. Thank you for joining us, and thank you, Stephen. So now we'll turn to Gordon. So if you can bring Gordon's up.
Okay, well, thanks very much, Chris. Good afternoon, still afternoon, everyone. I've been asked to talk about the Stormont Brake, which has been pretty high profile in the debates about the Windsor Framework. Let me say at the outset what I think about it. First of all, whenever it comes through and it takes form, or if it comes through and it takes form, it's a very sophisticated piece of constitutional engineering. We're sort of slightly indulged that the EU and the UK have spent so much time integrating into the framework aspects of the Northern Ireland constitutional settlement. So that's one of the striking features of it. The other thing is I don't know when it's going to really be used. I don't mean that flippantly. We're told on the one hand that the reach of EU law is being diminished significantly, or will be diminished significantly by the Windsor Framework. So that would seem to remove some of the scope for using it. And if it is used, you'll see that there's so many thresholds and question-begging phrases within it that it's difficult at one level to see how it would ever reach the finishing line. But I say that without knowing precisely what it's going to look like. And some people may have an insight that they can share with us. If you're interested in chasing this down, having a look at more detail, some of you will already have done this, so apologies if you have. But for those of you who haven't, those would be the two main documents that you should have a look at. So the draft decision of the withdrawal agreement itself. Why that's important is that has Article 13A, which I'm going to come back and talk about, which will be slotted into the protocol, Article 13A. But it also includes, and forgive me, I was talking to Chris earlier and I kept saying universal declaration instead of unilateral declaration. So if I keep saying universal declaration, I mean unilateral declaration. It's just a habit I have. But anyway, there's a unilateral declaration by the UK regarding the role of the NI institutions. And you need to look at that. And you need to look at Article 13 and see the interplay between the two to understand how this may take form. The other thing that you can have a look at, and I've seen some people have brought copies with them, is the command paper 806, the Windsor Framework, A New Way Forward. That gives the UK government's narrative around the framework and the UK's government narrative around how the brake will work. Have a peek at that. There's obviously been commentary about what the UK government has said and criticism of sound bites and so on and so forth. You can form your own view on it. But the key point in that, and this is really one of the key points to make today, it references the need for legislation. So what we have so far is still, if you like, a shadow type of idea of what we're going to have with the Stormont Brake. We will need changes to legislation, most obviously the Northern Ireland Act 1998. Make some suggestions as I go along about where that may happen, but we don't actually know precisely what this is going to look like. That's one of the criticisms of it. It's also one of the points of interest in it. So why have the Stormont Brake? Well, I could go for audience participation and say who studied European studies, but I'll not. But if you studied European studies, everybody knows there's a general problem with the democratic deficit in the EU process. There has been ever since. Part of the Brexit debate itself was about whether or not it's a good idea to disentangle the UK from the European Union's institutions and process. Fair enough point. In relation to the protocol, it has a particular sheen, particular colouring in relation to Northern Ireland, because you'll know that the protocol, basically the gist of the protocol was a tranche of EU law was taken and slotted in the annexes to the protocol, became a part of Northern Ireland law, allied to the supremacy doctrine, and was to apply on that basis. And under Article 13.3 of the protocol, there was, I don't think the term dynamic alignment is in Article 13.3, but it's the imagery of anytime anything within the protocol was changing, there had to be a process of tracking that in Northern Ireland. So the point about it was Northern Ireland becomes a receiver of law, not a lawmaker, and it's reacting to what comes its direction. So essentially, it was a duty to accept as NI law changes that were implemented at the European level in relation to legislation that had effect under the protocol. Now, again, that was criticised and with some legitimacy from the perspective of a democratic deficit. In Article 13A, which is the Stormont Brake, introduces at least an option. I was going to say for the Northern Ireland institutions, that's not quite right. Introduces the option for MLAs within the Northern Ireland institutions to start a process that can lead to a break on a measure that's being amended or adapted under the existing protocol regime. Now, the idea of a break, I'll come back to, but the idea of a break is not entirely novel within the protocol itself. So those of you who are keen protocol watchers will know that under Article 13.4, the UK government had a break option in relation to new EU measures. So basically, you have the scope of the protocol and the legislation slotted in under the annexes. The European Union comes along and says, here's another piece of legislation that we think belongs in the protocol. And the UK government says, yes, but that's outside the scope of the protocol. That's new legislation. And the UK government had an option of putting a break on that. I'll just park that point out because I'll come back to it later. But if you can just bear in mind, there has been a previous break. Some people have called it the Westminster break. I think Steve Pearce in his blog called it the Westminster break. Anyway, our focus today is Article 13A, which introduces the Stormont Brake. Now, how to trigger the Stormont Brake? Obvious point, institutions need to be functioning. That's not me saying that. That's the UK government saying that in the unilateral declaration. It's clear if you look at the unilateral declaration, the Assembly, so use language, the Assembly has been in regular session. So we're familiar with the idea of the NI institutions having a staccato existence, on, off, on, off. There's no regular session. Institutions have to be working, and MLAs must be individually and collectively seeking in good faith to operate the institutions and references obligations in relation to participation in the institution. So it's an obvious point, but it's a point that's made with some force in the declaration. It mirrors in part, it's not the same as, but it's similar to the petition of concern mechanism. Now, the petition of concern mechanism being a source of controversy in Northern Ireland, it has been changed last year. Legislation amended Section 42 of the Northern Ireland Act to give form to agreements within the new decade, new approach agreement. Basically, 30 MLAs from two parties. And you can go on and you look and see the party strength. You can see there can be interesting arithmetic exercises in relation to two parties getting over the 30 MLA threshold. 30 MLAs from two parties notify HMG, His Majesty's government, about their concerns about a change to an EU law measure within the protocol. So something is coming along, amending existing law under the protocol. 30 MLAs notify HMG of their concerns about that. Now, this is where it becomes difficult. And these are where the thresholds and the hurdles come in. Before 30 MLAs can issue a notification, in the declaration, you'll see it says MLAs must have sought prior substantive discussion with HMG and the NI executive. They must also engage with stakeholders, business, civil society, who may be affected by it. And must also have made, and the phrase that's used, albeit it's just in the declaration, reasonable efforts to consult with the EU. So it's not an ambush. Starting a process can't happen by way of ambush. It has to be by process of deliberation in advance of it being done. I was discussing with Chris. We'll see whenever if HMG go forward and say there's a problem with this, they're meant to do it within 2 months of the measure being adopted. So that's a very tight time frame if you wait for the measure to be adopted, but we can talk about that. But anyway, that's point number one. If 30 MLAs want to bring this forward, there has to be a serious a serious and focused engagement with government actors and stakeholders. This is where it becomes, I think this is where it becomes particularly difficult. So these words are taken from Article 13A itself. So this is in the draft decision. So these words, one would presume, will make their way then into the statute book. Any notification to HMG has to, first of all, say that the revised EU law measure is significantly different to that which went before. And of course, this is perhaps patronizing people, but significantly different is a very expansive phrase. I'm not quite sure what it means. I'm not aware of any guidance what it means. I'm not sure you can give guidance what it means. But MLAs have to, first of all, show and satisfy HMG, as we'll see in a moment, that the measure is significantly different to that which went before. And Article 13A also refers to the revised measure afterwards, the revised measure would have a significant impact. I've underlined all of these. I couldn't decide which were the most important parts and the most confusing parts. A significant impact, query, what is a significant impact? Specific to everyday life of communities in NI, measured by comparison with whom, in a way that is liable to persist. So if 30 MLAs want to go ahead with this, they have to, I suppose one would say, come up with an evidence base that this is going to be the effect of the change, the legislation in question. Now, the role of HMG, this is the last slide, I'm nearly at my minutes, aren't I? Role of HMG, well, first of all, HMG can form the view. So the MLAs notify HMG, we think there's a problem with this legislation. We think the various criteria met. HMG can form the view that, among other things, the significant difference and significant impact thresholds are not met. Now, I've put challengeable way of judicial review, question mark. We do love a good judicial review in Northern Ireland, so there may be a judicial review of that decision, but you don't know what way it's going to look, but you can't think the courts are enthusiastically going to rush into a dispute between political decision makers about the meaning of significant difference or significant impact. But anyway, HMG, that's the first thing. HMG can say, no, there's no issue here, we're not going to proceed with it. If HMG accepts that the relevant steps and thresholds have been met, it must then notify the EU in writing through the Joint Committee on the protocol that it considers the break should apply. So put in parenthesis, such notification must be made within 2 months of the publication of the relevant measure. And I think the stay on the measure takes effect 2 weeks after that notification is given. I should have added that point of detail. Anyway, if the UK government thinks, okay, potentially there's an issue with this, notifies the EU. And then you flip over to Article 13.4, which I mentioned at the start, because this leads then to efforts to resolve the matter through the Joint Committee under the new rule procedure in Article 13.4. So you remember Article 13.3 originally was measures that were tucked in underneath the blanket of the protocol. Measures outside that were subject to 13.4. This then takes the measure, makes it a new measure under Article 13.4. Disputes can happen in that context, and there's scope here for disputes to be referred to an international arbitration panel, so rule of law applying if there's disagreement between the EU and the UK. Aoife's going to talk about the CJ-EU, but there's a potential role here for the CJ-EU in the sense that questions of EU law can be referred by the arbitration panel to the CJ-EU. Now, this is where it becomes the Northern Ireland Assembly comes back, and this is why I've said there's been considerable indulgence of Northern Ireland, because if the EU and the UK agree that this should be adopted as a new measure, the way things are currently positioned, we don't have the legal framework, so we don't know for sure if this is what happens. It then comes back to the Northern Ireland Assembly. So we've had discussions at the supranational level or the intergovernmental level. It then comes back to the Northern Ireland Assembly, and at that stage, the Northern Ireland Assembly decides by cross-community vote whether to accept it. So you'll know the petition of concern is usually petition of concern and cross-community vote. Petition of concern in this context then leads to an elaborate process, and at the end of that, it comes back to the Northern Ireland Assembly to decide by way of cross-community vote whether or not to accept it. Now, it doesn't specify if it's a 50-50-50 or a 60-40-40. That'll be in the legislation. But the Assembly has the option either to accept the measure or to reject it. This is a story that could go on and on. Don't worry, this is the last point. If the Assembly says no, and HMG does not override that outcome, so HMG has the option of overriding an Assembly vote, and it's not wrong with it. You can look at the parallel that's in Scotland with the gender recognition legislation, so it is still the pull of central government. If the Assembly says no and HMG does not override that outcome, the EU can then take appropriate remedial measures of its own. But as I understand it, if the EU's taken appropriate remedial measures of its own, it then goes back to the Joint Committee potentially with the option of referral. So it could take a while. Anyway, that's all I'll say on it at this stage. I was going to mention something about the courts, but it's probably better to wait until after Aoife's talk about the Court of Justice. And then if there are any questions about the NI courts, I can address those. So thank you very much.
So we'll go on to mine. I'm going to talk about the impact of the framework, equality, on the human rights and equality provision of the. That's it there. Thanks. Thanks, Declan. On the human rights and equality dimensions of it. This is going to be a very short talk. Basically, the conclusion is going to be that the Windsor Framework has no effect on the human rights and equality provisions. But let me, so those of you who just want the conclusion, that's it. Now you can go to sleep. For those of you who are more interested in how I reach that conclusion, that's what I'm going to do in the next 5 or 6 minutes. No more. So the starting point is Article 2 of the original protocol, we'll call it that. And this will be familiar to many of you, basically ensuring no diminution of rights. This is a complicated provision in itself. And of course, there has been a judgment in the High Court, and there'll be another judgment from the Court of Appeal in the Spuck case on the meaning, aspects of the meaning of that. But that's not what we're going to talk about today. The main point that I want to make with regard to Article 2 is that the no diminution requirement brings with it Annex 1. And Annex 1 specifies a particular set of directives, the scope of which cannot be diminished. And so this is, as it were, the specified element of the no diminution requirement. The no diminution requirement goes beyond the Annex 1 provisions, but at least it covers the Annex 1 provisions. But beyond that, and this is where it begins to link in with what Gordon has been saying, we then turn to Article 13, which is what Gordon has been talking about. And in terms of Article 13, there are 2 provisions that are particularly important with regard to Article 2. One is Article 13.2, which basically says that the concepts, the ideas, the directives that have been mentioned in the Annex 1 have to be interpreted in conformity with Court of Justice jurisprudence. But in addition to that, we have dynamic alignment in 13.3. That is, notwithstanding Article 6.1, which we can ignore for the moment, where the protocol makes reference to a union act, that reference shall be read as referring to that union act as amended or replaced. So if one of the Annex 1 directives is amended or replaced, then Article 13.3 kicks in, and that has to be reflected in Northern Ireland law as amended or replaced. And that's in perpetuity. No time limit. So the protocol bill would have done away with, or threatened at least, that dynamic alignment in 13.3. And we don't really need to get into the details of it, but the conclusion is relatively clear. Wasn't clear whether that was intended or accidental. There was a big debate on it in the House of Lords, debate on the bill, and questions were put and ministers responded, but that was the beginning of the debate rather than the end of the debate. That debate no longer needs to continue because the withdrawal of the bill is probably the most significant impact of the Windsor Framework on the equality issues. But the most relevant provision that might have impacted the equality provision would have been the Article 13A that Gordon has been mentioning. That is the one that implements the Stormont Brake. And it implements the Stormont Brake with regard to a set of EU laws that are referred to in the protocol that impact Northern Ireland. So theoretically, therefore, Article 13A would have applied to the Annex 1 directives and therefore done away with dynamic alignment, right? However, when we turn to the draft decision itself that introduces the Stormont Brake, we'll see that Article 2, which is what Gordon has been talking about, is limited in its application. And this is a very important limitation. And the limitation is found in 2 lines at the end of that paragraph. So the paragraph, in terms of what Gordon has been talking about, covers union acts, only a limited number of union acts that apply. And it's the Union Acts in the first indent of heading 1 and heading 7 to 47 of Annex 2 to the protocol. And the third subparagraph, Article 5.1. Basically, that's, I read it so you don't have to, the goods and the customs, so the single market in goods and customs arrangements, and only a limited subset of those. So you will see, therefore, that Article 2 is not affected because it specifically does not refer to that paragraph applying to Annex 1 and the directives mentioned in Annex 1. So, conclusion, no change from the original protocol, except importantly in withdrawing the protocol bill itself. Thank you. So now we'll turn to Katie, who is in Brussels, who will appear magically from her bedroom. I think. Katie, you're there.
Hi, Chris. Can you hear me okay?
Yeah, I think we can hear you very well. First of all, thank you very much indeed for joining us. I know you're exhausted, but
aren't we all at this stage?
Thank you.
Great. Thank you very much, Chris. And a special note of appreciation to you for facilitating this as a hybrid event. There are a number of us on Zoom and it's really appreciated. So thank you for that. I'm just going to share some slides. So now I hope you can see those okay. So I'm going to be talking about committees and consultation under the protocol and the Windsor Framework. And those are two things that we haven't really heard much about. They've been sort of operating in shadowy form, if you like, over the past couple of years. But actually, if we're looking at the nature of the Windsor Framework and what it entails and what we see in it, we realize that those two things have actually been really critically important. And so in my brief presentation, I'm just going to look at how they've become important, and then maybe in terms of what next, what the significance of those two things will be as we see the evolution of the Windsor Framework. So this will be familiar to many of you. This is the structures that we have for the UK-EU bodies overseeing the protocol, the UK-EU Joint Committee, that's Vice President Maroš Šefčovič, with James Cleverly heading that up, overseeing, of course, all of the withdrawal agreements and a number of specialised committees. The one we're most interested in is the one on the protocol on Ireland, Northern Ireland. The specialised committee's role is to make recommendations to the Joint Committee. And then under that, we have the Joint Consultative Working Group. Now, one thing that we've know, I say shadowy for a reason, they haven't been meeting formally for some time. So the Joint Committee met 9 times. The last time they met formally was last February in 2022. Specialised Committee met 10 times. Last time it met was last March. But the Joint Consultative Working Group, that's been meeting monthly and quietly doing its very important work in terms of looking at the legislation that will be applying to Northern Ireland under the protocol, mutual exchange of information and consultation. I will be coming back to that. One thing that I sort of alluded to there is the ad hoc engagement that's been ongoing with business and civil society groups in Northern Ireland. It has been very much ad hoc, but through that there's been evidence presented and deeper understanding that I think we see reflected in the Windsor Framework. Now, in terms of the Joint Committee, obviously, it was established in the withdrawal agreement. Article 164 of the withdrawal agreement sets it out in detail. I'm not going to go through this in any way at all, but just to stress, actually, it's a really important body with very significant powers. So you can see it can adopt amendments to the agreement. It can take such other actions in the exercise of its functions as decided by the Union and the UK. Most importantly, of course, is this element of Article 1645, which basically says that it's able to adopt decisions amending the agreement up until the end of next year. So 4 years after 4 years from the end of the transition period, is necessary to correct errors, address omissions or other deficiencies address situations unforeseen, provided that such decisions may not amend the essential elements of this agreement. That's not up to me to decide whether the withdrawal with the Windsor Framework does that or not, but that's a notable point. It also has the capacity to change the tasks assigned to specialized committees. I'm going to come back to that. So under the protocol already, I don't expect you to read this. I'm just going to note a few things. You can see that the Joint Committee has considerable decision-making capacity across substantial and important parts of the protocol as it exists. The areas that we see used now in this Windsor Framework relate to customs. So it's adjusting the criteria for bringing goods into Northern Ireland. Adjust the criteria relating to at risk, as Billy has already mentioned. It also, you could see it as adopting recommendations with respect to avoiding controls in ports and airports in Northern Ireland. We see two significant changes to Annex 3 under Article 8 about appropriate measures with respect to VAT and excise. Article 13.4, as Gordon's already mentioned, essentially we're seeing through the use of the Stormont Brake aspects of law that would have otherwise been under Article 13.3 being moved into 13.4. And then this, I've put it in purple or lilac because I'm not really sure. This is a sort of interesting issue about the role of institutions created by the 98 agreement. And as Gordon's already spelled that out, that's in effect used in a different way through the Stormont Brake. So this is the decision-making capacity of the Joint Committee being exercised as we see it in the Windsor Framework. The UK-EU Joint Committee decisions so far, they made a number of them just in great hurry towards the end of the transition period. I've just got these here, and this is a chance for me to plug the Post-Brexit Governance NI website from the project that Billy, Lisa Whitten, and I are on, led by David Finnemore. And the key thing there is the decision that is being changed, it's being replaced in the Windsor Framework. That's one decision that the Joint Committee made back in December 2020 that's being replaced here. So what are decisions being made in the Windsor Framework? And I stress this is not a comprehensive list. This is just the headline overview. So we see that it's changing the tasks assigned to specialized committees. So there's a new form of the specialized committee, which I'll mention in a moment. It's bringing in a new rule book for allowing goods into Northern Ireland under Article 5.2. Stressing the sort of stretching, if you like. This has already been mentioned, what's allowed into Northern Ireland, that at-risk test, it's disapplying rather than completely removing certain aspects of Annex 3. And we've also got the Stormont Brake in there. One thing I really wanted to mention actually is the next point. And again, there's a lot of info here, you don't have to read it all, but essentially it's about the new powers, like the extended powers that we see of the Joint Committee. And I think this is quite important to note. The Joint Committee has been given new powers and they are potentially quite significant. One is in relation to this safeguards issue. So as we see in the Windsor Framework, because the EU is making significant concessions, it's also strengthening its capacity to respond fairly strictly. And one of those is the capacity to suspend the green lane. Now, one thing you'll really see throughout the Windsor Framework as a whole is the stress upon finding mutually agreeable solutions, mutually satisfactory resolutions. So there's a lot of emphasis now on that relationship in the Joint Committee. We have to hope that it will meet more regularly and more formally than it has been. One thing is, if the green lane is suspended after some issue has arisen, for example, significant illegal activities, the Joint Committee can still decide to let it continue, or if it's suspended, if the green lane is suspended in these circumstances, the Joint Committee can amend the decision to make alternative provision. And this suggests that could potentially be quite a significant adjustment again for that GB-NI trade. Notably, that would have to come in within 2 years of this initial decision that we're expecting probably by the end of this month to come into play. So that's something to keep an eye on. Other issues in relation to Annex 3, those powers are already there. the Stormont Brake, new commitment to intensive consultations in the Joint Committee. One element to bear in mind is something that's already there in the protocol, but will perhaps take on new significance, which is if something is knocked from dynamic alignment through the Stormont Brake into Article 13.4. So it needs basically the approval of the UK to proceed. It comes into the Joint Committee to deliberate over, and then the Joint Committee then can take any decision necessary to address the issue of contention. So that's worth bearing in mind. Also, one last thing on democratic consent, we see another unilateral declaration from the UK. It's saying that it will commission an independent review if in winter next year, when we have that vote from the MLAs, if they vote just by simple majority rather than cross-community basis to continue with Articles 5 to 10, they will have an independent review and they will send those recommendations from that to the Joint Committee. And then the Joint Committee again has new potential to seek appropriate ways and methods of presenting problems. So again, bearing in mind the scope of that Joint Committee, we could see some potential adjustments again through that route. So I've got, I'm coming to the end now. So in terms of the Joint Committee, we know UK has confirmed that the First Minister and Deputy First Minister will be able to be in attendance wherever they're discussing issues relating to Northern Ireland. We see new forms of the specialised committee. So it's really hard to unpack it because it's spun in certain ways, but essentially those two new bodies that they're talking about to deal with the issues of alignment, etc., and the impact of EU regulations on Northern Ireland and discussion and expertise, those are essentially forms of the specialised committee as exists already. There's also new subgroups being constructed under the JCWG, which is at the moment the legal provision is that it's officials. We've also seen an emphasis upon a promise from both the UK and the EU, a commitment to establish new mechanisms for structured engagement within UK-EU structures. So those are still to be developed and formalised, and the details on that are still to work out. And then last but not least, we have a really significant statement. It's a unilateral statement from the EU Commission on engagement with Northern Ireland, and there are three elements there that I'm highlighting. So one is information to people in Northern Ireland. This includes the upcoming Commission's work programme. This is something that the EU doesn't do for its own member states, let alone for countries with association agreements with it. It's really quite significant. It's offering information sessions and workshops. It's also offering public consultations. People can request engagement directly with the Commission on its upcoming work programme and any element relating to it. It will engage in discussions in the JCWG, including those subgroups. And also it's committing to, when it does, so new policy and initiatives in the EU will have to have an impact assessment relating to Northern Ireland. And in the impact assessment, when it's coming forward in the final iteration of that policy, they will have to say how Northern Ireland stakeholder views on the implications of that policy or piece of legislation will have been taken into account. So there's a lot positive there to keep an eye on in terms of consultation, but also we shouldn't underestimate quite how significant those sort of behind the scenes non-political elements of the evolution of the Windsor Framework protocol will continue to be. Thank you.
Thanks, Katie. Thank you very much. Aoife?
Good evening, everyone. I'm currently reading Michel Barnier's Brexit diaries, and in January 2019, he talks about having Brexit fatigue. I think, well, by the time we get to March 2023, I think we're showing a stamina that perhaps Michel didn't appreciate back in 2019. So I'm going to talk about the Court of Justice, the European Union, and a little bit about arbitration. And much like what with Chris's presentation on rights, much hasn't changed. Much of it is very, very similar or more or less the same. So I won't take up a huge amount of your time on that basis, and the fact that I'm aware of all the kinds of fatigue that this produces. So I'm going to cover three main points. Kind of the role of the CJEU in the context of international trade agreements more generally or more broadly, the role of the CJEU in the Windsor Framework, and then the practical likelihood of it becoming involved. So I'm actually going to start with the middle one first. So the role of the CJEU is largely the same, with small potential, as Gordon has already outlined, of its inclusion in the Stormont Brake. So there is a possibility of issues being referred to, and that is an additional thing, this area where the CJEU will be involved. But as Gordon has sort of outlined, getting to there even is a long and tortuous path that I'm not sure we would necessarily get to all that often, if ever. Now, the core role of the CJEU more generally, of course, is to protect the integrity of EU law and, as specific to the protocol, the single market and goods. And in that, it is there to ensure the consistent interpretation of EU law's meaning. And I think that is very significant and important, right? Because that consistent interpretation of what it means allows for some certainty in the system for governments, for businesses, for all concerned. So that idea of keeping that consistent interpretation is an important element of certainty when you're talking about a market that is as big as the EU's. So in that, there isn't any new role within the framework with regard to that in specifically, but where you have is where you will see some changes, I think, is in the creation of the green lane. And in that, it's that, that simplifying of the structure is likely to lead to less use of the CJEU, because those goods that will, as Katie has already outlined, the way that will function with the Joint Committee, the elements that are put into that green lane will not be subject to EU law and EU regulations. Now, the operation of the green lane still remains within the purview of the CJEU. So in the operation of it, you could see the CJEU getting involved, but within the green lane itself, as regards to the regulations, other than that oversight, you are much less likely to see the CJEU getting involved. So here you have an area not where they don't necessarily have purview, but where the likelihood of them becoming involved is far reduced. So it's not that we have a huge chunk has been taken away from them, but rather from a practical perspective, you're seeing it a lot less likely to be there. So it will clarify, could see potentially a scenario where it would clarify the rules around how the Joint Committee decide what's in the green lane or not. For instance, you could see where the Joint Committee might seek the CJEU EU's guidance on that in a preliminary reference. You could see potentially the Commission taking an infringement procedure, but within the actual operation and what those goods are and whether or not they comply, that is much less likely to occur. And this kind of falls into sort of the point in point 3 that for a whole variety of reasons, it is less likely you're going to see them involved. So the increased consultation processes, I think, are very significant, as outlined in detail by Gordon, but also by Katie. There's increased number of committees, for one thing. There is the inclusion of business. There is this whole process before any law is changed. So it is much more likely that any issues will be headed off before they actually occur. So because of these consultation and specialized process. So I think that will probably reduce the volume or the potential for the CJEU to be involved. I would also say the increase, the data sharing, which we haven't really discussed today, will lead to less likely that we're going to see even suspension of the green lane that Katie mentioned, because it has increased basically trust and confidence. It demonstrates an increased trust and confidence between the UK and the European Union. And that because there is that constant monitoring of the data at the various different border sites, I think that's going to lead to much more trust and confidence, and therefore less likely again that you're going to lead to a conflict. Also, I think with regard to the very specific, and we've yet to see, as we've heard with state aid, how this is going to play out, but with regard to things like medicines or with regard to agri-food or pets, even that these amendments are going to create very specific rules for Northern Ireland, and Gordon already alluded to this, but it is creating very specific what we, lex specialis, a very specific law for Northern Ireland that is very unique to Northern Ireland. And when you have a scenario like that, I think it is more likely that it is the Joint Committee or one of the specialised bodies that will resolve any contextual issues that arise, because it is very specific to Northern Ireland, and therefore probably less of a concern to the CJEU, frankly, because it won't apply in the rest of the European Union. So it's not necessarily going to impact on the market. So I think for that reason as well. Also because, I think potentially the way we're presenting it might seem like it's more complicated, but kind of the aim of the Windsor Framework is to make trade in goods easier on a practical day-to-day basis. And if it is that streamlining, then it actually might be useful to have the CJEU to get involved in certain issues. So if there is clarification necessary, it might be a scenario where it would be better to go to the CJEU through preliminary reference procedure and actually ask for clarification as to what this means within the EU legal context. So while I've kind of talked about the reduced role, if the object and purpose of the Windsor Framework is to make things more straightforward for trade in goods, it might be that actually bringing in the CJEU in particular scenarios might be worthwhile and profitable for everybody involved, simply to have that kind of clarification, which is the ultimate aim of the preliminary reference scenario anyway. From another kind of practical point, of course, is that there were proceedings had begun. The Commission had commenced infringement proceedings against the European or against the United Kingdom. It started in 2021 for failure to implement the protocol, and those have now the Commission is not proceeding with those infringement. So the CJEU hasn't actually become involved at all as yet. That was sort of the early process of becoming involved, and that is now, even though we've had obviously lots of upheaval and lots of disagreement, we haven't seen the CJEU's involvement. So we haven't actually seen how the CJEU will go about approaching it, or how the registry will go about approaching it. So it is how they will go about thinking about this lex specialis for Northern Ireland has yet to be really seen, really thought through. Going back to the first point, and just as more of a general point from an international law perspective, the role of the CJEU as the ultimate arbiter of what EU law is or means from an international law perspective is actually quite standard. So most international trade agreements will have something, will designate a body or a court to say what this specific provision means. Anyone who's familiar with international human rights law, say any of the UN bodies, say the Covenant on Civil and Political Rights, its committee is the ultimate arbitrator of what that treaty means. So from an international perspective, it is quite common to say this body will decide what this law actually means. So it is, with regards to the trade, seeing it as the withdrawal agreement and the trade agreement and the framework all together, it is quite standard practice in international law and international trade law to do that. In terms of the arbitration process, that within international trade terms, that is also quite common. And interestingly, I think the way that the arbitration is set up, and it is already up and running, the 25 people have been appointed, so that we're already kind of on the road with the arbitration body, is that it is very much a standard way of going about solving trade disputes, and the UK will, and already is with regard to Australia and New Zealand, going to be involved in a lot more of these arbitration bodies. It already was through the European Union, but it was the European Union was dealing with that. So there is a capacity issue, I think, that the UK is going to have to think about with regard to arbitration more generally, even beyond the framework and with or beyond the European Union about dealings in these kinds of arbitration bodies, because it is going to be a growing significant area. Now, the UK, luckily, in London is one of the hubs for international arbitration, so there is quite a large capacity actually with people with experience of this. But with regard to specific trade intergovernmental issues as opposed to, say, corporate bodies and states, that is a very specific form of arbitration. And if you look at sort of the other big examples of these kind of ones, like the WTO, the arbitration body is less legalistic actually than the WTO's one. The WTO's, while not a court, acts very much like a court. They issue dissenting opinions. There's an appeal process. Whereas actually the arbitration body here is a much more traditional form where there isn't any dissent, there isn't any appeal. It's one body. It's much more. So it is much more like a traditional trade arbitration body than, say, even what you'd have at the WTO. And I shall leave it there.
So over to you. Lots of potential questions there. And I'll now see if we can get the chat function up. Here we go. And chat. There we go. Great, thank you. Several questions online. Perhaps if we may take some of those first of all. Yeah, so this is a question for Gordon from Richard Bullock. So it would be useful if you could clarify if MLAs have any role in relation to the new as opposed to existing EU laws amended. So is that entirely a matter for the UK government in Article 13.4? He's really asking, I think, about the role of MLAs, the Assembly, in the 13.4 new rule procedure that you mentioned. You did address that, but perhaps you could say a bit more about that.
Yeah, I mean, 13.4 formally, it's the responsibility of the UK government within the framework of the joint committee, but
just talk us through the procedure as you understand it.
Thanks, Chris.
Oh, sorry. That was meant to be helpful.
not in the slightest. No, the procedure 13.4. So the point is that the legislation that's coming forward doesn't fit within the pre-existing scope of the protocol. That's flagged up by the UK government, and then it goes into the joint committee for resolution of the issues, and there can be again arbitration around the questions arising. There's nothing formally within the protocol that gives the Northern Ireland institutions a role in that, as far as I'm aware. But one would imagine that if the institutions were up and running again, and there was the, shall we call it a pure Article 13.4 point, that the Northern Ireland institutions would have some sort of consultative role in feed-in. But I don't know if there's something particular. Perhaps Richard's aware of some MOU type arrangements meant to kick in, but I'm not aware of one.
Thank you. So a question from Roy Montgomery for Katie. Katie, can you hear us okay? So how do the new consultative arrangements compare with those that apply to Norway and other EEA members? And does she envisage an informal role for the Irish government in communicating Northern Ireland concerns, whether raised in the North-South Ministerial Council or otherwise? So two questions really. One, comparison in terms of the consultative arrangements with the EEA and potential informal role for the Irish government. Katie, do you want to come in on this?
Yes, so as it happens today, I was at a seminar in EFTA House, and one of the breakout sessions I attended was on agencies and shaping decisions at the EFTA level. So the EEA Consultative Committee exists, of course, and that's for social partners, and that meets once a year, and you have the European Economic and Social Committee in there, as well as EFTA social partners. So that's something that they have that we don't. Of course, the equivalent would be in the TCA, under the TCA, and the domestic advisory group that we have for that, and also the Civil Society Forum. Also, one thing we don't have, that's a slight aside, but is kind of relevant, is the role of agencies. So the EEA member states can have participants on the management boards of these relevant agencies, which does have an influence, I think, in terms of the effects and impacts of internal market. That's an aside. What we have instead has been less satisfactory in many ways, because of course, as I say, there's the stuff of the TCA which is going forward. Essentially what we got was a joint consultative working group, which is officials, as I say. That's completely unique across the EU, and it serves a purpose, but it is detached from, it doesn't necessarily get evidence from the ground in NI. What's proposed here in the Windsor Framework is very innovative. I'm cautious about it because the details are still to be worked out. And as I mentioned, we do have the commitment from both sides to establish mechanisms at all levels. We don't know what that's going to look like. So that will be really important to keep an eye on. Interestingly, both of them say they want, so both sides say they want this to evolve over time. They recognize the importance of insights and on the ground experience in that. And that, as I mentioned too, the commitment to consultation is really, really important and very unusual. With respect to the role of the Irish government, of course, I would imagine that informal role would continue, perhaps, in different forms. But actually, again, what we have in the Windsor Framework is the potential to not be relying on that. So the fact that you would have that consultation, you would have those experts, be they officials or others, feeding into the Joint Consultative Working Group. The fact, eventually, we will have the capacity to scrutinise the legislation in the Northern Ireland Assembly itself, and then to feed back in to the committees in the overseeing the Windsor Framework Protocol. That will all be very important. So those relationships matter. Of course, relationships with member states matter, but in this, potentially, we've got something very unique and distinctive that attempts to, at least in some ways, address the unique situation of Northern Ireland.
Thanks, Katie. Question for Anthony and again, you, Katie. How stringently do you think the criteria for triggering the Stormont Brake that you set out, Gordon, how stringently do you think they're likely to be applied? And there's a sort of halfway comment at the end of it. Is there a risk that the UK government's interest in selling the agreement in Northern Ireland may mean that it's made out to have a much wider scope than it actually does from a legal perspective? You may or may not wish to address that second part.
Yeah, second question's pretty political, isn't it? So I'll avoid that one.
Yeah.
In relation to stringency, the closest to the legal text that we have so far is the draft decision that includes the draft Article 13A, and the significant difference and the significant harm thresholds are within that. Those are thresholds to which effect will have to be given in domestic law. For me, it's not really a question of stringency. It's what is going to be agreed between the parties, and it'll come in. Now, the question more broadly is about how. I don't think there'll begin any negotiation on those, but the question is how the existing unilateral declaration takes form in the NI Act, and whether or not there'll be any watering down or ratcheting up of what's currently envisaged. And I mean, this is a great answer to be able to give because it's very evasive. We won't know until we see the legislation.
I mean, maybe there's another way of taking the question, which is you mentioned the possibility of a judicial review in the domestic context. And I think you were hinting at least that some of our friends in the audience are unlikely to want to intervene in very, very readily in judicial review context domestically. But I suppose the stringency question does arise with regard to the International Arbitration Panel, right, which potentially has the opportunity, as you said, to review the decisions of the UK to trigger and to refuse. Do you have any sense? Maybe it's more a question for Aoife as to the potential stringency of the International Arbitration Panel judging those questions, which they will have to decide at some point. I think he's bowing to you.
Well, though I think I'm probably going to give a similar answer. I mean, I suppose importantly, I suppose arbitration isn't supposed to be legal, right? It's not a court. And what you might end up having is that they refer to what that means to the CJEU as to what it means. So I could see if it works its way up and nobody is willing to, or there is disagreement as to what is significant and what is not significant, or even what is communities. I think Steve Pearce, we've referred to in his blog, talked about the Jewish community in kosher food, for instance, and the difficulties they were having accessing it. And just is communities in the NI constitutional sense communities, or is it a broader idea of communities? So you could see where issues like that could make their way up, and where it could be judicial review internally, or you get to the arbitration and the arbitration body decide that that's a matter of EU law to decide, depending on where. So if it's domestic legislation, I could see it landing in the judicial reviews context, or at the arbitration level that it goes to the CJEU. You could also potentially have a look at some of the, say, arbitration bodies generally in international law they're not public, they don't publish, so there isn't that sort of looking to precedent. There is no precedent in international law anyway, but you would, so there's a difficulty there in finding other examples. You could potentially look at what came out of NAFTA, so that's the North American Free Trade Agreement, and what came in there. You could potentially again look at the WTO, but I don't see them as being readily usable in these contexts.
I mean, it does raise the question that is I think quite intriguing from Gordon's talk about the role of the Assembly in all of this. And how far the Assembly gets to vote at any point prior to the very final stage that you pointed out, Gordon. Does the Assembly have a role in that process prior to the final decision whether or not to sign off on it?
Not in the terms of the unilateral declaration. It cross refers to the petition of concern model in section 42. And the classic petition of concern model is petition of concern is triggered by 30 MLAs, and then there's an assembly vote on a cross-community basis within a pretty quick order after that. I mean, there's to be the consideration period and whatever under the revised section 42. But there's nothing in the unilateral declaration that suggests that the assembly has any role until after, if call all the big beasts of, including potentially the EJ on a reference from an arbitration panel have resolved things, and then the assembly as a vote at that stage. So perhaps that's something that'll be tweaked in the legislation. I don't know, but it doesn't look at this stage as if that's that's envisaged there's any earlier rule.
And are the decisions of the Assembly restricted to what is a devolved matter? In other words, when changes are made to existing EU law, and the Assembly then gets to trigger, 30 members of the Assembly gets to trigger it. What's the devolution element here? Or is there a restriction on the Assembly that they can only deal with the final vote on a devolved matter, or do they have a say on any matter that applies to Northern Ireland? I mean, let's take an example, right? So let's imagine, and this is one of Stephen's, and I'll ask him to come in this as well. let's say there's a change in the sanctions regime, which is, I'm assuming, not a devolved matter at the moment, but it has an impact on Northern Ireland exporters. There's another dispute somewhere, another Ukraine somewhere else. They bring in a new sanctions regime. It applies to Northern Ireland, but it's not a devolved matter. Does the Assembly get to vote on that or not? What's your understanding?
Well, I'll let Stephen answer the difficult one about sanctions, but instinctively you would say the Assembly only votes on devolved matters, but it's also possible, is it not, that if the legislation is being amended, that there can be something put in to include a vote on any matter arising under the protocol. We can phrase the way arising under the protocol, and there's some precedent for that because international relations are not a devolved matter. But under I can't remember Schedule 2 or Schedule 2 Paragraph 3 or Schedule 3 Paragraph 3, whichever way around.
You're just showing off now.
No, I can't remember which one it is. I just remember there's a 3 and a 2, and I hope this is the last question for me, Chris.
I doubt it.
But there is a tweak in relation to, you remember, North-South cooperation, which would have been reserved or accepted matter, but the way in which the wording was used in the schedule allowed the Assembly to act in that context. So. But it would have to be dealt with in the legislation. It couldn't be assumed. I mean, the powers of the Assembly are limited by Section 6.
Stephen, would you like to come in?
Yes, certainly. So it's an interesting question, but in terms of actually looking at the technicalities of it, what actually applies in terms of Article 5.4 of the protocol, which then refers you to Annex 2, which lists the various levels of EU law that apply to the trade of goods, in particular the export of goods. And the very final list, once you get through about 20 pages, you'll see reference to Article 215 of the Treaty of the Functioning of the European Union, which specifically relates to any decision that the EU made in relation to sanctions. So in theory, or not in theory, how that actually is meant to act in practice is that Northern Ireland exporters, if they're exporting goods, need to be aware and follow EU sanctions rules as opposed to the UK position on that.
Right, and therefore potentially then changes in that sanctions regime
Correct.
at the EU level will apply willy-nilly to Northern Ireland exporters.
Yes, that's right.
Thank you. Katie, do you want to come in on these questions? I think silence means not. Yeah. Do you want to give?
Thanks. Daniel Holder, CAJ. I have a question for Gordon. Funnily enough, to make this even more complicated, and it's on, you mentioned the petition of concern, but it's on the relationship or potential relationship with the Stormont Brake with the, what you could call the St Andrews veto, i.e. the veto that was introduced under the St Andrews Agreement, whereby ministers can't take decisions on their own outside the programme for government, because if they're significant or controversial, which is practically anything. Just thinking through in terms of the sort of measures of the Assembly that the Stormont Brake could apply to what extent will they all inherently involve ministerial decisions? So, for example, a minister might have to introduce regulations or even primary legislation to amend EU law to keep pace with the protocol. And if that's the case, then surely the St Andrews veto would apply as well as the Stormont Brake. So why would, and go through how stringent the criteria is for the Stormont Brake at any point, but in reality, why would, if one larger party wanted to block a new bit of EU law, why would they use the Stormont Brake if they could just use the St Andrews veto and block it anyway? And with that, in that context, would the sort of Stormont Brake not become a bit redundant or academic?
Yeah.
I don't know, Daniel, but my best guess is, so if you look at the unilateral declaration, and this is going to be a long way around to answer the question. If you look at the unilateral declaration, it talks about before it can be triggered, the MLAs have to engage with the executive committee. And I wonder, because we don't know what that means at this stage, but I wonder, as you fashioned at the St Andrews Brake or the St Andrews veto, I wonder, will that actually be something that will be addressed in the context of whatever the legislation fleshes out in relation to that. I can't imagine that it would be advantageous to have a number of circumstances where mechanisms that were meant to work in one way would be frustrated by other mechanisms within it. An example would be the way in which the petition of concern was written out of the democratic consent process under whatever its schedule, I can't remember. But that the petition of concern in that context could have bedeviled the whole process, the democratic consent process, pursuant to Article 18 of the protocol. So it was dealt with in the regulations and dealt with in the statute. And I would think that if there is a potential for the St Andrews veto to cut across, that's something that whatever statutory scheme is brought in would seek to preempt or address. A waffly answer, Daniel, but.
Richard Bullock has commented on the question, which is, I think the last question is confusing regulations with directives. I have no idea whether that's true or not. Katie, would you like to come in on the previous questions? Your computer died, so
yes. Apologies. Thanks for having me back in. So I missed some of the answers there. So these are just going to be general comments on the question of the role of the Assembly. So obviously an awful lot of this is being worked out at the moment in discussions with the parties. And you do get the impression that obviously, as has been pointed to by others, there's an awful lot of detail that isn't spelled out. From the EU's point of view, this is a domestic issue now, and there is quite a bit of scope, I think, in those discussions with parties to be quite clear about certain things. For example, about whether it is necessary and at what stage to go to a vote in the Assembly. So if reading it carefully, it is clear that that vote essentially, in effect, lifts the brake. So you need to have cross-community consent in order for the law to apply, rather than for the law not, or for the amendment and replacement not to apply. I think that's a significant distinction. And also just in terms of this is a matter for interpretation, and I know that important people are interpreting it differently at the moment. But whether it's necessary indeed to have the Assembly functioning fully for the Stormont Brake to be applied. So there is a section that says essentially once it's up and running again, then only then can you have the Stormont Brake potentially be used. But after that, those who continue to, MLAs who continue to be there working in good faith, could potentially still have use of that Stormont Brake. So this is all to be spelled out in much more detail. But as I say, the really important thing is actually now the parties have quite a bit of responsibility in making sure that the legislation that comes forward addresses all these potential ambiguities and potential risks, I think, too, with respect to the operation of this brake.
Thank you. Yes, at the back. John Campbell, I think.
Hi, mainly a question for Gordon, but also anybody else who might have a view on it. I'm sorry to come at this again, but it's from a slightly different perspective, and it's again on the question of the significant impact mainly, and also the significant difference question. So one would assume that at some point, if there's an attempt to trigger the brake and the government says, no, we don't think that's a significant impact, that's the sort of thing which might go to judicial review and get some sort of definition. But is there anything currently in either domestic or international law which can get us towards some sort of practical example of what a significant impact might be? So, are we talking about something which would need to be at the level of, threat to life or something less than that? Is there any precedent at all out there which gets us to a practical definition?
Well, when everybody else is thinking, I mean, there is obviously a potential relationship here with Article 16. Mm-hmm. But maybe Katie can come in on that. Gordon.
Short answer, John, is I'm not aware of anything. I mean, what I'll say to you in all honesty is the law is full of phrases that are contain a lot of latitude within them intentionally. They're given definition on a case-by-case basis, and whenever things are being determined on a case-by-case basis, there's always an element of evaluative judgment on the part of the persons who are making the decisions. So if I could come up with a definition of significant difference or significant impact, or in Article 2 cases, real and immediate risk, I would write a book on it, sell it, and retire happily, because I'd have answered all of the problems that are to be addressed on a day by day basis. Can I also say, John, I know that you're the business correspondent, and my heart sank because I thought the question would have been for Stephen.
Katie, would you like to come in on that?
No, I was just agreeing with you about the safeguard measures. So they'll be essentially it's trying to take Article 16 into MLA's hands in that assessment of significance.
Aoife, yes, please.
I suppose from an international trade perspective, and I'm not sure if Billy is still there. I don't think he is.
No,
but,
he's not.
in international trade law, there would be, by analogy, some things that you could potentially work with, like substantial transformation when you're talking about goods. So this happens in manufacturing when a good, say, it could occur here, for instance, you import a good, does it substantially change into something else so that you would call it something else? So, and that has been worked through various cases that have come through. So often what it comes down to, and I think this probably is where significantly different and significant impact will actually have to work together as to the specific context of the good or the product or the directive. And that in that specific context, has it changed substantially in its impact on people? Or you could also look to like how much of it has been and why it's been changed. So it could be the type of thing where you look at the commission and why in their discussions they were changing it. Was it changing just to give clarity as to a meaning, or was it changed because there was a CJU decision, for instance, that said that this was not functioning at all with regard to the treaties and therefore needed to be changed? So I think it will be a case-by-case decision, but I think probably in each one it will be looking perhaps at why the directive was introduced, what it was a response to, was it something about clarifying, or was it something that needed to, say, greatly expand because of change in technology, for instance. So I think it will be looking at how it happens within trade law on analogous phrases. Of course, as Gordon said, there's a lot of these kinds of phrases out there. I would imagine that that's the kinds of questions or the kinds of things that would be taken into account. But I think that list will be contextual to what is actually occurring in any scenario.
I mean, there is a more technical element to the question, which is, I'm sorry, you're all going to hate this. So the changes to the protocol, which include the Stormont Brake, are made finally by the Joint Committee that Katie was talking about. The Joint Committee will be the legislator in this sense, but the Joint Committee is restricted in terms of the changes it can make in the protocol. So the Joint Committee, as was said by Katie, is only allowed to make changes so far as it doesn't affect the essential elements of the agreement and of the protocol. And so my understanding would be that therefore these changes to the protocol have to be read, at least initially, as conforming to the fact that the essential details of the existing protocol are not being changed. And that, I think, does mean that if you interpret the Stormont Brake as essentially a safeguards clause, or essentially rather similar to a safeguards clause, then it does come rather close to Article 16 and to the general provisions in international law and other treaties as to what safeguard clauses do and the potential extent. So there is a jurisprudence, as aware, in, I think, in international law and safeguards clauses that is potentially relevant to the interpretation of some of these provisions, though taking into account Gordon's point that, of course, all of these are context specific. So your question, John, I think is one which is likely to run and run. or good or ill. Questions? Oh, thank you. Thanks, Evelyn. Does the increased role of committees, international arbitration, etc., mean the power of democratically elected bodies to make decisions on issues related to the protocol has decreased? There's been a lot of talk of the brake countering the democratic deficit, but is that really the case? Gordon, you want to start off? I think this is one for the complete panel, isn't it, really, Gordon? Because your initial introduction to it was that it was addressing the democratic deficit.
Well, it's a very good question. I mean, it's the argument about what sort of model of democracy you want to have. Do you want to have everything? And that's part of the argument in favour of Brexit, of course. One of the arguments was you take decision making back closer down to the local level. The counter argument is in a globalised, internationalised setting, you can't actually ever finally close yourself off from other decision makers and other institutions. So I'm afraid it's a philosophical choice for the person who's answering the question. Do you want everything done locally and think that's the only way to do things democratically? Or do you accept that there are linkages elsewhere? And that's also a model of democracy.
I mean, there's a kind of legal element to it as well as the philosophical, which is in terms of the committees that we've been talking about, particularly the Joint Committee. To what extent is the Joint Committee itself reviewable? Yeah. So the question I was responding to John on, which is that the committee can only act intra vires. So there is a mechanism, therefore, for reviewing these committees itself.
Yeah, but it's Tower of Babel stuff, isn't it? Because then who reviews the committee, and are they further away again from what would be regarded as a local democratic space?
Well, I think in this context, the arbitration panel reviews the committee, so it sort of feeds back into this question. You're right, Aoife?
It is a very good question, and I think it's a question that has been a problem for international law really for the last 70 years, is that increasing use of international bodies across all areas, not just trade. And this is a question the EU has always grappled with, where is the appropriate place for decisions to be made? Where is the most effective place for decisions to be made? I think in the Stormont Brake, there's a slight hint of accepting that, and when it talks about the impact on the communities, and the idea that this mightn't be an issue for the rest of the European Union at all, so for the remaining 27 members, but it might be an issue in Northern Ireland. So I think there is a nod towards the idea that this might be a specific problem for this specialised legal regime that doesn't exist elsewhere. And therefore it's necessary for that kind of consultation with the Assembly, with the devolved institutions in particular. But it also I think is a problem within the UK, because the way the Brake operates, ultimately who's making a lot of these decisions is the government in London, it is Westminster. And you saw that with the Internal Market Bill as well, is the sort of this idea of pulling back a lot of the powers to London, some of which included powers that had been devolved to Northern Ireland, Scotland and to Wales. So there is that broader problem, but also within the UK itself about what are the appropriate decisions to be made at each level. And it is, I think, ultimately a political decision as to where it is the most appropriate. I think there are nods towards it, to trying to resolve it. There are other things that could be done around MEPs, etc., but that doesn't seem to be on the cards at the moment. But I do think it is an important one to look at in all the contexts, and with regard to devolution itself and how it's operating, how devolution is perceived. And the questions that Chris has raised is significant in that frame, but also then the UK within that sort of international framework of how these decisions are made and where they're made and why we might want them to be at various different levels.
I mean, clearly there's a greater degree of trust that's being placed in the government in London to make what are perceived to be the right decisions. But ultimately, I'm right in saying, am I not, that the European Commission retains the right to take infringement proceedings. So there was a lot of talk before the announcement that those powers would be rolled back. My reading of it is that those powers have not been rolled back. Is that your understanding?
That's absolutely my understanding as well, yeah, that the commission is still there and can take infringement proceedings. I think it's less likely to, but absolutely it's still there.
But a political decision, as it were, rather.
Yeah.
Katie?
Just a few points. I mean, one, I very much look forward to seeing the ways in which the Assembly is equipped to conduct its role of scrutinising legislation. So this would be, obviously, legislators have a hugely complicated challenge now to face, and it's got more complicated, perhaps, with respect to the Windsor Framework. So those the functions that the Assembly plays goes, of course, way beyond the Stormont Brake, a lot around how it scrutinises legislation, and that'll be interesting to see how that will be developed. Also, we should bear in mind
what the staffing of the committees is going to be.
Yes, indeed. Also, we should bear in mind that civil servants, so officials, are playing a really important role here, and they've been given more of a structured role through the Windsor Framework with those subgroups under the JCWG. And of course, they'll be operating ideally under ministerial direction as well. So that's something, you know, it's not always a case that you need to have direct MLA or elected representative engagement to have legitimacy. And also what the EU is, what the UK and the EU are proposing here is very innovative, as I say, with these new structures and mechanisms. And it's complicated, yes, but perhaps like democracy should be complicated. And maybe this is in its own way democratic. So ideally, of course, we would all really would like to see the Assembly and Executive functioning as it should be, and being able to meet these new challenges. But the richness of the mechanisms that enable expertise and evidence and experience to come forward, insights to come forward from NI itself, it is really, it's a really welcome opportunity. And perhaps in some ways there's an opportunity for a sort of democratic enhancement that isn't necessarily the same as having MEPs in the Parliament, but it actually could make a significant difference to our experience and management of the Protocol Windsor Framework.
Thank you. Stephen?
Yeah, just a very quick point to make that one aspect that I have been very pleased about the announcement to be made is that the reference to stakeholder engagement groups in terms of Northern Ireland and businesses, just to say that groups like the CBI and the Chamber of Commerce done an incredible job over the last few years going to both the UK government and the Commission and raising what they see as the concerns of businesses in Northern Ireland. And clearly in the announcements that have been made, those concerns have been listened to and actually been respected. So I'm pleased to see that actually that's been recognised as an ongoing mechanism going forward to ensure that that voice of Northern Ireland businesses will continue to be listened to.
There's an intriguing relationship, is there, between the provisions on the Stormont Brake and the plethora of new engagements that are permitted by Northern Ireland stakeholders. So, question really, to what extent do those stakeholder engagements have to have been mobilised and effectively taken into account before MLAs are the 30, whatever we're going to call them, Spartans, who are going to be able to trigger the provisions of the Stormont Brake? Is there a relationship here between those engagements and the operation of the brake?
Yeah, there's a quizzical paragraph again that's in the unilateral declaration, which says that before the 30 MLAs can notify HMG, they have to have, among other things, actively sought to engage with HMG and the executive, and also, I can't remember the form of words, but with the stakeholders.
Yeah.
And that's a condition precedent, if you like, to moving forward, even before you get to the stage about the significant impact and so on and so forth, that has to happen. The question is when it should happen, because there's the 2-month window for the government to give notification. And if you're a group of 30 MLAs and you have to engage, you presumably have to be starting to do so well in advance. Let's say if it's a directive that's coming through, it's in its draft stages or whatever, one would think that would happen. Right. But on your specific question, is there a link? Yes, there is, but it remains to be seen what way it's put into the legislation.
Right. So the engagement then might well be and this comes back to Katie's point about the Assembly, would be well advised, the Assembly would be well advised to be spotting legislation that's coming up well in advance in order to be able to engage fully and to be able to demonstrate that were they to want to, or envisage the possibility of triggering the Stormont Brake.
Can I say something, Chris, just on that? I mean, essentially, all of those new structures and mechanisms, the new subgroups under the JCWG, all of that is intended to avoid these things being a problem. So the idea is they hear and they test and they engage way before it gets to the point of, to the Assembly, and then that last resort of the brake being triggered. So this, I think, is really worth bearing in mind, that their intention is to get that information and to make adjustments and to frame it in different ways, such that it sort of avoids such a situation as these things would be problematic. I think that's the intention there.
So it's a classic, almost English administrative law idea of you have to exhaust alternative remedies before you can trigger the brake.
Yeah, it's meant to be last resort. Yeah.
Other questions? Yeah,
I just add by analogy, I think what's been interesting with the human rights bodies in Article 2, which obviously isn't covered by the framework as you set out, is that it does create a lot of additional work, and the resourcing of, is it really critically important there? Because if these bodies have to, in order to do all these bits, which are essential and important, they have to be properly resourced, staffed and funded, because obviously the EU and the website and everything will be excellent, and this includes the stakeholders. So it's not just the various bits of the committees that will have to be properly funded, but the ability of stakeholders and how widely we see stakeholders, whether or not it's the CBI or the business community, but also, these directives can affect a huge amount, like the example I talked about earlier, the Jewish community and the access to kosher food. So the sort of how we go about making sure all the stakeholders are in a position to engage fully and practically as is intended, as Katie had pointed out, I think will be really important. So the kind of resourcing, I think, will be essential.
Sounds like Section 75. Last questions.
If you look at the
if
you juxtapose the recitals in the draft decision of the joint consultative working group on the rules of procedure with the substance of the decision itself, and while all of this, of course, is intentionally high level and lacking in detail and very interesting indeed from that point of view at this stage, there does seem to be, I would suggest, a very clear underlying intention that stakeholders are not defined. That's probably a very good thing indeed. They're not defined, but that they will qualify for membership of one of these new specialized structured subgroups and will therefore have the potential to influence the activities of the Northern Ireland Assembly before, during and after those activities. In other words, this will be a continuum.
Thank you. Shall we call it a day? And all this is before we get to the EU retained yeah. That's for another day. Thank you very much for coming. Thank you for those excellent questions online. Thank you for bearing with the weather and turning out. And thank you to our panelists. Excellent. Thank you.